So my job at this conference is to be the resident skeptic. What I've been paid to do. And I am on record as a critic of standard models of hate crime legislation. And my invitation to this event was clearly intended to import a kind of opposition that would keep the rest of you from having a general hate crime love fest. And I'm not going to disappoint because that would just be unfair. As David hinted yesterday, there's nothing worse than organizing a set of speakers in reliance on their past work, only to have them thwart your reliance interests by using your event to roll out some altogether new change of course. So as much as many of you would perhaps like it if I told you that our discussions yesterday assuaged all my fears about hate crime legislation, I'm going to be true to my role, and I'm going to play at least the devil's advocate, if not the devil himself. But I want to be clear from the start that I'm a modest critic, or at least I'm a reluctant critic, because I set out to defend hate crime legislation those years ago. And what happened was I wrote myself into a critical position, and I know that with friends like me, who needs enemies, right? It was the late 90s, and Matthew Shepard had just been killed on a buck and pole fence outside of Laramie, Wyoming, which is my hometown. It's where my family lives now. It was a buck and pole fence that I built when I was 16 years old, working with the Youth Conservation Corps in the late 70s. And my mother, on the spot, became a ferocious advocate of hate crime legislation within Wyoming, and a ferocious campaigner for hate crime legislation in Wyoming. And about the same time, I was asked to do a panel at the Penn Law School and to speak about hate crime legislation, which I'd never spent time before thinking about. To my frustration, as I'd explore the various avenues available to me with which to champion this kind of legislation, I found myself persuaded over and over again by the problems that were addressed to each of those avenues. So I ultimately wrote an initial modest but critical piece. Well, so the phone rang one day, and it was the Republicans calling me to Washington to give testimony on the then proposed 1999 federal hate crime legislation. And I agreed to go, and my mother was furious, just livid. I mean, in my family, you do not go to Washington to in any way aid Republicans. And we are card-carrying Democrats. And so that was it. She was just furious. But, I couldn't resist. So I went, and I was preparing my, my little talk in my hotel room about 9:30 the night before the testimony was scheduled, and the phone rang in my hotel room. And it was one of the leading lawyers for the ACLU. And he said, I'd really like to meet with you. Come on down. We'll have a drink together because you are articulating precisely our position about this bill. And I thought, the ACLU? I've come to Washington called by the Republicans, and I'm going to be articulating the ACLU's position. So this was too intriguing. I had to go down and figure out how this was possible. And he told me the following story. He said, we are opposed to hate crime legislation he says, I'll give you the story and it'll illustrate our reasons. And he told me the story about a defendant who'd recently been, or a convicted defendant who'd recently been in a bar fight, and it was a typical case of assault. And when they hauled him in, they found that he had a swastika tattooed on the inside of his mouth. And it reached back almost 25 years in his life to an early time when he'd, sort of been enamored with, I don't know, whatever group it was that caused him to tattoo the inside of his mouth in this way. And what the ACLU was worried about was precisely the implication of freedom of association. Because what they recognized is that hate and bias crime legislation would make sensible a reaching back in time for any evidence whatever that would suggest that somebody had an enduring disposition towards one or more groups of the sort that hate crime legislation targets. So they took it to be an affront to freedom of assembly, freedom of association. Well, in any case, I got to call my mother and tell him that, I went to Washington and I got in bed simultaneously with the Republicans and the ACLU, and maybe that bought me a 6-month reduction in the amount of time she didn't spend talking to me, but I think she still didn't talk to me for about 6 months. And to this day, when I told her I was coming over here to spend time talking with you all about this topic, she certainly registered her hope that I would finally see the light. Now, My particular concern with hate crime legislation, of course, focuses on the enhanced penalties that so many statutes impose for already punishable offenses. So the federal government in America enacted typical hate crime legislation in passing the Violent Crime Control and Law Enforcement Act of 1994, which enhances penalties by 3 offense levels above the base level for an underlying federal offense if the defendant intentionally selected his victim because of her race, color, religion, ethnicity, national origin, gender, disability, or sexual orientation. So for Joanna, this is indeed an example of the discriminatory selection model, not the hostility model, because it doesn't reference hate or bias in its terms. So take, for example, aggravated assault. Gets a base level score of 15, which can merit a penalty of 18 months in prison. If committed with the requisite, or committed in a way that satisfies the requisite conditions of this statute, it will get an elevated score of 18, which can result in 33 months in prison. So imagine 2 defendants, each of whom have intentionally bludgeoned someone in an alley. One does it because he intends to steal the man's wallet, and the other does it because the man is a Jew. The second can go away for more than twice as long as the first. So now there are 2 traditional bases for punishing criminals within the Anglo-American criminal justice system. The wrongdoing that they've done, which is a function of the harm that they've perpetrated out in the world, and the culpability with which they've acted, which is a function of the mental state with which they did that external wrong. So, for example, murderers and manslaughterers are thought to commit the same wrong, namely the taking of a human life, but to act with quite different culpability, the murderer being a purposeful killer, the manslaughterer being a reckless but accidental killer. Murderers and thieves, on the other hand, are thought to commit different wrongs, different offenses, the taking of human life, the taking of property, but to do so with identical culpability because each acts with the purpose to bring about these wrongs. So now new crimes are typically specified or enacted whenever we discover a kind of activity that's harmful to a victim or to a community in a way that no other crime captures, or that's sufficiently culpably done to merit separate specification as a separate crime. So that means there are 2 ways to justify hate crime legislation. One is to claim that victims of hate-motivated crimes are harmed more than other crime victims, and hence that hate-motivated defendants ought to be punished for perpetrating greater harms, i.e. greater wrongs in the world. And then the second is to claim that defendants who act out of hate or bias are more culpable than otherwise motivated defendants, and hence deserve greater punishment for that reason. So let's work through the merits of each of these justifications. So there are 4 sorts of harms that advocates of hate crimes have referenced in justifying enhanced penalties. So the first claim that's been made is that hate crimes produce greater physical injury to their principal victims than do otherwise motivated crimes, and therefore hate crime perpetrators deserve more punishment. Now, this is a claim that Paul very nicely debunked in his presentation yesterday. But you know, it's still around. It still gets asserted. And it's particularly important to see the problem with the argument, even if it were true. So, 2 sociologists in the past report as follows, quote, "Bias crimes are 4 times more likely to involve assaultative behavior than are crimes generally, and they're twice as likely to involve injury to the victim and 4 times as likely to require hospitalization." Now, if this claim were true, and we're prepared to set it aside on the strength of Paul's research and Paul's references to other research, but if this claim were true, it would provide a very puzzling justification for hate crime legislation. Because imagine the following analogous argument. We should have crimes of bad temper, because first, bad-tempered people are 4 times more likely to do crimes that involve assaultative behavior. And second, their crimes are twice as likely to involve injury and 4 times as likely to require hospitalization. Now, what's wrong with this argument apart from the empirics? Well, the answer is that bad-temperedness isn't itself a harm. The perpetrator's bad temper is being used as a proxy for the more serious physical injury with which it's said to correlate. But there's no good justification for using such a proxy because proxies are always over and under inclusive. Bad-tempered people don't always commit crimes involving assault, and normal-tempered people sometimes do commit assaults, and sometimes those assaults are very injurious. So rational legislators might employ a proxy such as this, or an analogous proxy, when the proxy is more provable than the thing for which it's a proxy. But that's not the case. The proxy in this case is less provable than what it's a proxy for. So whether a crime involves an assault and whether that assault has produced serious physical injury are both far more provable than whether a defendant committed the assault out of bad-temperedness or racial hatred. Right? It's much easier to prove physical injury and the seriousness of it than it is to prove a mental state or a background motivation. So if the degree of violence or physical injury caused by a defendant is relevant to the severity of his sentence, and I certainly think it is, then all those who commit violent assaults, whatever the motive, whatever their temper, should be punished for aggravated assault. And we can specify categories of aggravated assault to capture our intuitions that punishments should be graded according to discretely specified types of injuries, so that disfiguring injuries are punished more than permanent injuries, that are punished more than temporary injuries, and we can factor in psychic injuries and so forth. Okay, so the second claim that's been made is that hate crimes cause greater psychological trauma to their immediate victims than do other crimes. And now this is a claim that Paul has in fact very credibly vindicated. And it's one that resonates from talking with all of you with the lived experiences of many of you who work with victims of hate crimes. So, as one advocate has written in a manner that echoes Paul's interesting data that we examined yesterday, quote, "A biased crime attacks the victim not only physically, but at the core of his identity. Stigmatization has been shown to bring about humiliation, isolation, and self-hatred." And other advocates have similarly claimed that hate crimes produce feelings of vulnerability to future violence, fear verging on paranoia of strangers, feelings of self-blame, feelings of helplessness, sadness, depression, lack of trust in others, and so forth. Now, I'm not going to raise any empirical doubts about these claims because I have very considerable respect for the work that Paul and Barb and others of you have done to make good on these claims. So I'm going to take it from the experts in the room that the empirics support the claim of increased psychological trauma. And now the question is, do we have a good argument for the enhanced penalties of the standardly drafted pieces of hate crime legislation that we can readily find examples of? Well, now clearly the same old proxy problem is going to rear its head. To justify hate crime legislation on this basis is to use the defendant's motive as a proxy for what really heightens the gravity of the offense, which is the victim's psychic trauma. But hate and bias are particularly bad proxies for a victim's psychic trauma. It's not hate that hurts, it's the perception of hate that hurts, and so Paul's research incredibly nicely shows. An assault that's in fact motivated by hate, but that isn't perceived as being motivated by hate, can't be said to cause the heightened trauma claimed for hate crimes. And inversely, an assault that's not motivated by hate may nevertheless be perceived as being so motivated, in which case there may be elevated psychic trauma, notwithstanding the absence of hate. So if psychic trauma is thought to be the gravamen of the offense, then the law shouldn't be concerned with the motive of the offender, but rather with the perception of the defendant's motive by the victim. And even, of course, this retains a proxy function because perception of hate is not the same thing as psychological harm. A victim of hate-motivated assault might perceive the hate but be no more traumatized by the assault than he would be if he hadn't perceived that motive. So if one really wants to adjust penalties to the psychic trauma experienced by crime victims, then the best thing to do would be to argue for a new form of aggravated assault, one that adds the element of the victim's extreme emotional distress to the offense. So a defendant could then be held liable for this new kind of elevated, aggravated assault if he negligently or recklessly brought about acute and disproportionate psychic trauma, whether he was motivated by hate or greed or lust or just raw indifference. So the third classic argument for the increased harmfulness of hate crimes goes like this. Hate crimes don't just harm the principal victim, they harm the entire community of people who share the characteristics that is the object of the defendant's hatred or bias. So Eric Holder, the Deputy Attorney General of the United States, said when he was testifying with me before Congress back in 1999, quote, "When a black man is harmed, I'm harmed. When a black man is made to suffer, I am made to suffer." Now, one response to this argument for the enhanced penalties of hate crimes is to reject the relevance of vicarious harms when gauging the degree of wrongdoing that a defendant has committed. So after all, you might think that it's as serious a wrong to murder a man, whether he's the father of four or a curmudgeonly old hermit. To argue otherwise is to say that the wrongness of a defendant's act in part turns on the popularity of his victim. That is, on how many family members and friends and caring acquaintances he has who are then vicariously injured by his injury. But I actually think that's probably right. I think that collateral harms probably properly go into the assessment of a defendant's wrongdoing, so that someone who negligently runs down a child does even more harm if it turns out that the mother is standing there watching. And when we set severe penalties for assassinations of public officials, for example, we're properly taking into account the collateral harms caused by those acts, the harms done to you and me as we cry for a lost leader. So I won't have a beef with the vicarious harm argument on the basis that vicarious harms are irrelevant to assessing wrongdoing. So what beefs do I have? Well, now I'm going to have some empirical doubts. Am I really more traumatized by crimes to persons with whom I share intimate characteristics? Or is it the fact that when the bell tolls, it tolls for us all? Now, it certainly seems rational, and we were talking about this at dinner last night, it certainly seems rational to feel greater fear for our own safety when those just like us are picked out as victims. But it's hard to punish a defendant more for what he's done to a given victim because he somehow casts light on what others might do to other victims in the future. Right? So that isn't actually the argument. It's certainly not the best argument that's being made when people talk about vicarious victimization. Rather, the claim is that in causing the principal victim humiliation and self-hatred, the defendant is simultaneously also causing such trauma to those with like attributes. It's that this defendant is harming me now, rather than just illuminating that I might be harmed in the future. Right? But now, even if it's true that we're harmed by harms to those with whom we share physical or psychological similarities, should the law honor harms of identification? So that when, for example, Eric Holder first said, when a black man is harmed, I'm harmed. At first I thought, well, that sounds right, or that sounds intelligible. And then I thought, well, that's an odd admission of narcissism. What, it has to be all about you? That is, it's an odd admission of a failure of empathy, right? That somebody who's very much like us commands a form of empathy, sympathy, in a way that by admission others don't. If it's true, it's not clear that it isn't a vice, right? And so while law might properly redress collateral harms, it's not obvious that it should cater to admissions of vice. Well, in addition to the empirical questions and concerns about legally paying homage to forms of sort of self-oriented empathy, we again have the proxy problem. Because again, the hateful motivation of the defendant is actually a poor proxy for the vicarious psychic trauma of members of the victim's community. Proving communal perception of hatred through victim impact statements, for example, would be a much better proxy for proving outright communal psychic trauma. And proving outright communal psychic trauma would appear the most reasonable requirement if one's punishing a defendant for causing communal psychic trauma. So in the end, if defendants deserve more punishment whenever their crimes send ripples through a community, then prosecutors should be required to directly prove such ripples of fear. They shouldn't be allowed to prove or put to the task of proving poor proxies for those vicarious harms. Okay, now finally, proponents of hate crime legislation urge that all of society is harmed by hate crimes, not just the immediate victims and not just groups to which they belonged. So this fourth harm-based argument goes by the name of the social harm thesis, and it's advanced in three forms. So one version of the argument stresses the risk of vigilantism for hate crimes. So hate crimes motivate blood-feud acts of retaliation if they're not dealt with extremely severely. But now this is a funny argument. We should punish the defendant in proportion to the degree to which he might be wrongfully retaliated against by others. Right? If we want to deter vigilantes, we ought to punish vigilantism, and not those who are the targets of vigilantes' unjustified attacks. Second version of the social harm argument is that hate crimes will cause a general breakdown of social order if not dealt with severely. Well, I don't know, all crime cuts into our sense of order, our sense that society works, our sense that the social contract is being kept. I'm not sure that there's anything that can be said about the corrosive effects of hate and bias crimes that can't be said of all other crimes on this score. The third social harm argument is that hate crimes polarize society and corrode our egalitarian ideals, and for this reason they ought to be particularly harshly punished. Well, maybe. But there's an old saying among philosophers that Hitler converted more people to natural law than Thomas Aquinas ever did. Similarly, the gruesome New Bedford gang rapes might have actually increased solidarity across sexes, as evidenced by the vigils held across the country by people of both sexes after that event. And the horrible Matthew Shepard case attracted enormous sympathy for the GBLT rights movement from the straight community. So this argument seems suspect. And if it's going to carry the weight of justification for hate crime legislation, then considerably more needs to be proved in order to say that hate crimes merit enhanced penalties on pain of social polarization. Okay, so I've worked through the arguments for standardly crafted hate crime legislation predicated on claims that these hate crimes cause greater harms and are therefore more wrongful. And as I've suggested, I think there remain real difficulties with all of these arguments, even empirics aside. So our search for a convincing rationale remains unsatisfied. So let's turn then to the second kind of justification for hate crime legislation, the claim that defendants who act out of hatred or bias are more culpable than otherwise motivated defendants, and for this reason deserve more punishment. So while a death is a death, those who kill intentionally are more culpable than those who kill negligently. And so they're punished considerably more, and rightly so. And so as the argument goes, those who kill out of racial hatred are more culpable than those who kill for other reasons. Okay, now if hate is construed as a culpability requirement, a true mental state requirement, like intent or premeditation, then it's crucial to recognize that hate crimes depart from all other crimes in three very significant ways. And this is the crim law, this is the crim law theorist arriving to say, leave my crim law alone, right? Barb and I were talking about this. So first, hate crimes punish defendants' motivations in a manner unique within the criminal law. So the standard means of measuring culpability in the criminal law has been via a very spare set of mental states. It's asked, did the defendant purposely cause the prohibited harm? Did he know he would cause the harm? Was he at least reckless with regard to causing that harm? Or was he negligent for causing it? Purpose, knowledge, recklessness, negligence. Those are the four mental states with which the criminal law has classically been concerned. Those are the four mental states, and really the only mental states, that the criminal law has used to grade offenses. So standardly, the criminal law has been quite unconcerned with defendants' motives, except to use those motives as evidence, for example, of intentionality, of purpose or knowledge. So you're a murderer whether you kill for money or for love. And a mercy killer is at one in the eyes of the law with a contract killer. But to determine whether a defendant committed a hate crime or a bias crime, adjudicators have to look beyond these mental states to the motivations with which defendants acted. Now, it's traditionally been true that if a defendant purposefully or knowingly did what he did as a result of a good, or at least an exculpatory motivation, that fact is entered in to some of the defenses that he might claim. But before hate crimes, bad motivations didn't enter into the prima facie definition of offenses or further served to inculpate the defendant. So specific intent crimes, though, you might, if you were all criminal law students, you'd be putting up your hand, if this was about 2/3 of the way through a criminal law course, you'd be putting up your hand and you'd be saying, well, what about specific intent crimes? So specific intent crimes require further motivations beyond those to do the act in which one's caught. So think about burglar. What do you have to do to be guilty of burglar? You have to break and enter with the further intent, the further motivation to commit a felony therein, to steal, to rape, to kill. Or attempted murder, what do you have to do? You have to do what you're doing with the further motivation to bring about the death of a person. Or what's called baby treason. The defendant has to do what he does with the further purpose of assisting the enemy. So these crimes appear to have motivational mental states, motivational mens rea. So perhaps they provide the precedents for hate crimes in a way that makes hate crimes not at all novel at all. So it takes away my argument to Barb, leave my criminal law alone, right? But this brings me to the second difference between the mens rea of hate and the traditional mens rea with which the criminal law has long been concerned, including the traditional mens rea of specific intent. Because hate and bias are not goals. Hate's an emotional state, while prejudice or bias is a dispositional belief state. So to act so as to get money, so as to rape, so as to steal, is not to act on an emotion. It's rather to act so as to obtain what one perceives as a future good. It's to pursue a goal. Hatred isn't a future good. It's not a goal. It's an emotional state within which one acts. One doesn't seek to achieve it by one's actions. It rather accompanies one's actions. And prejudice isn't a goal either. It's rather a standing disposition to make judgments about others without further evidence, and to act on the basis of false beliefs with regard to them. So specific intent crimes like burglary or attempted murder criminalize the having of certain goals, the pursuit of certain goals. But hate crimes criminalize the having of certain dispositional beliefs or emotions. And this brings me to the third special feature of hatred and bias as culpability requirements. And that is that hatred and bias towards particular groups of people are character traits. The emotions and the false dispositional beliefs with which hate crimes are concerned aren't occurrent states of mind. They're unlike goals that can be goals can be chosen. You can choose a goal, right? And you can dismiss that goal instantly. So unlike goals that can be chosen or dismissed instantly, hatred and prejudice are rather dispositions possessed over time, enduring aspects of a defendant's personality. So think about how, I think it was Paul, who put the distinction yesterday in our group between hate and anger. You distinguish hate and anger, right? And notice how he marked it. Hate's anger sustained over time, right? Did I get that roughly right? Roughly right, right. Hate's anger sustained over time, i.e., it's anger that's hardened into a character trait of a certain sort, right? Because standing dispositions just are character traits. That's what we mean by a character trait. What's a character trait? It's a standing disposition. To harbor hatred or bias towards a particular group is to possess a bad character trait. It's a disposition to feel hostility, to think derogatory thoughts, to jump to conclusions about someone. And when opportunities permit, to act in oppressive ways towards those that one hates or bears prejudice against. So the enhanced penalties of hate crimes, at least if justified on culpability grounds, punish defendants for having bad character. Now, many will be quick to say, no, they don't. They don't punish people for having bad character, only for acting on it. But of course, remember, already existing criminal law punishes for the underlying act, say of vandalism, plus the intent that accompanies it. The added penalty over and above the penalty for that underlying offense is for the hatred or the bias. And if that's not a proxy for claims of greater harm, then that constitutes not a chosen goal, but a character trait. Now, if the enhanced penalties of hate crimes punish defendants for prejudice and hate, i.e. for character traits, then they raise three very profound questions. First question, can we choose our character traits? Can we will our emotions? Can we will away our beliefs? I mean, most of us are pretty confident that would-be defendants can choose not to rape, not to kill, not to steal. But it's a lot less clear to what degree people can will away or choose not to have particular character traits. So at the moment at which a defendant is about to throw a rock through his neighbor's window, I'm pretty confident that he can choose to do otherwise. But at that moment, can he use an act of will to rid himself of his hatred of his neighbor as a Jew? Can you make yourself, by act of will alone, like someone? Can you choose to have emotions different than you do? Heck, I'm always trying to will that I like certain kinds of foods that I don't like, and I don't have much luck doing that. Can you choose to love someone? I've met a lot of guys who think so, right? They're the ones who go through a long list of reasons why you ought to love them, as if at the end of the day you can say, oh, okay, in that case I choose to do so, right? But of course at the end, if they're right, one's usually left wondering why one doesn't love them. And one is nowhere closer to loving them, right? It looks very hard to levy our will on our emotions. Now, people can alter their dispositions in a number of indirect ways. And millions of dollars are spent in therapy every year by people attempting to change their character for the better, right? And people can, with mixed success, alter their character by repeatedly putting themselves in circumstances that challenge them to behave in ways over time that will affect their beliefs and their emotions. So, for example, someone might not be able to will away his disdain for the poor, but he might be able to rid himself of that disdain by moving to the ghetto and volunteering his time to help those in need, so that over time his disdain fades to pity and then maybe ultimately to admiration for the hardiness that is required to persevere in poverty. And perhaps by punishing people particularly harshly when they do bad deeds out of hatred for their victims' gender or race or disability or sexual orientation and so forth, will motivate people to take actions that will indirectly alter over time their emotional responses to those characteristics. But I don't know about you all, but my mother always told me not to marry a man I was going to have to change. Because while character can be indirectly affected by willed actions, so it's not immutable, one's ability to affect it is clearly imperfect. And more important, such indirect measures are exactly that, namely indirect. You can't abandon dispositional beliefs or emotions the way the burglar can abandon his plans, namely by choice alone. So it makes all the difference whether criminal legislation targets goals or dispositional states. Criminal legislation that targets emotions and standing beliefs target things that are not fully and readily within a defendant's immediate autonomous control. And if law ought not to punish us for things that we can't autonomously control, then hate crime legislation is suspect for doing just that. Second question, is hatred or bias towards people because of their race, their religion, their sexual orientation, and so forth worse than other emotional states that often accompany criminal action? If hate crimes are going to remain unique among crimes in picking out dispositional motivations as bases for increased punishment, then we either have to be able to defend the claim that racial hatred or gender bias is morally worse than greed, sadism, jealousy, and so forth, or we have to be able to advance some reason to think that such hatred and bias is uniquely responsive to criminal sanctions in a way that greed and jealousy and so forth are not. I'm not sure we can sustain either of these arguments. You might think that group hatred, for example, is learned while greed and sadism is not, and that anything that is learned can be unlearned. I'm not sure this is obvious. And if we can't make a case for why group hatred and bias are unique among bad motivations, then we either have to think that hate crime legislation is arbitrary and hence unjust, because it picks out for extra punishment a set of emotional states that are a subset of a larger class of equally vicious mental states, or we have to generalize hate crime legislation by radically revising the culpability doctrines of the criminal law so as to, in each case, take into account and dish out punishment proportionate to the culpable dispositional states that motivate a defendant to do a criminal deed, whether it's racism or sadism or jealousy or sexism or road rage. And this brings me to the third and final, sort of most profound question about hate crime legislation and its use as a model for the radical reform of our culpability doctrines. So the third question: should the criminal law be in the business of punishing people for bad character? Inasmuch as hate crime legislation ultimately punishes people for standing traits of character, it's best explained by, and it's most at home within, what's called the character theory of the criminal law, the theory that takes the proper goals of the criminal law to be the punishment of vice and the cultivation of virtue. Now, these are distinctively non-liberal goals. Political liberals allow the state to use its power to make us act in ways that are right. But they've long insisted that the state may not use its power to improve our thoughts, our feelings, our hopes and desires, namely our character. So those of you who favor currently drafted hate crime legislation and its implicit license to use the power of the state to police and encourage good character, namely virtue, seemingly have to admit that you're not political liberals. You are rather what we call political perfectionists, who view the legitimate power of the state as extending to legislation that will nurture in us charitable, kind, courageous dispositions and eliminate selfish, cowardly, cruel dispositions. You're among those who believe that law can go beyond making our actions good. It can make us good actors. And you're not without good company, because you've got Aristotle on your side. But beware, because it's political perfectionism to which social conservatives reach when they seek arguments for why sodomy should be criminalized and gay marriage should go unrecognized and women shouldn't work and school prayers should be reinstated. It's the prospect of having leaders with questionable views about how to perfect people that prompts many to trade liberalism's tolerance of imperfection for the liberty that it buys. It's in its illiberal implications that hate crime legislation is profound, and it's in its illiberal implications that it is and ought to be, I think, profoundly disturbing, because such legislation suggests that the state has abandoned the ideal of limited government, the ideal that the state should confine itself to implementing the right and not the good. And as such, it's extended its power to affect not only what we do, but who we are. Well, that's the message I took to Washington a number of years ago. At the call of the Republicans and on their dime, I arrived to scold the Democrats that they were being insufficiently liberal. And that's not what the Democrats wanted to hear, and it surely turned out to be a perverse message for the Republicans to sponsor. So I'll stop there.
Questions, or actually not that quick. As a philosopher, I often find it useful to try to find disambiguate between different concepts, and I think the concept of hate crime might do with a bit of disambiguation. One suggestion I've been working on is redescribing hate crimes as specific intent crimes. That would mean saying that when I have this motivation, I try to cause the type of psychological harm and group harm that we associate by proxy with hate motive. That will mean, of course, that a lot of crimes now being categorized as hate crime would not be, because a lot of them are not motivated, are not conjoined with that level of thought. But it seems at least that is actually a worse crime to have this specific intent than just having the prejudice. So that's the first point, but that would mean a radical redescription of this legislation. The other one is you're talking about what's an object of choice for us. And I've been working on another suggestion, another concept of hate crime, where what we are punishing is not motive, and it's not intent, and it's not action, but it's acting for a reason. And hate crime is acting for a bad reason. So in that case, we'd be held responsible for making a decision, and that's definitely one of the things we can choose. And we can choose to treat race as reason, but that's a bad reason, so hence we could punish it more. So that's the second question.
Good, wonderful, love those questions. So, I don't actually think that recrafting hate crime legislation in accordance with your first suggestion, so as to construe the hate crimes to which legitimate enhanced penalties will attach as specific intent crimes, is that radical. I could fully embrace that, because I think we could credibly craft legislation that says it is a crime deserving enhanced penalty if you do what you do with the further motivation, namely with the goal to cause extreme emotional distress, or, for example, to drive the victim from the community, right? We could specify a goal that we take it to be prohibited to pursue through various other already penalized kinds of action. I think there's absolutely no problem doing that, but you are absolutely right to anticipate that that will get a fraction of the number of defendants we are currently casting the net over. Because while there are a few hate crimes that seem to fall within that mold, that seem to be perpetrated in a calculated manner so as to deliver a message, so as to have further effects that reach into the future, to drive people from the community and so forth. I thought Neil was very convincing yesterday when he said, quite frankly, lots of defendants, I mean, they're just in the barroom brawl with somebody whose race they have just a dispositional reaction to, but it's not calculated to do anything, right? It's just the classic responsive criminal behavior triggered by a characteristic that they have a dispositional affect with regard to, but it doesn't, in fact, function in the way that specific intent crimes function. So that would be to recraft hate crime legislation in a manner that somebody like me and somebody coming from criminal law would understand and embrace, but it would be to target this much of the population of folks currently targeted by our existing hate crime statutes. Second wonderful question is the Kantian approach. Namely, why don't we think of hate crimes as being wrong deeds pursued with the wrong reason, with bad reasons, right? And of course, those in the Kantian tradition famously think of wrongdoing as embodying the reasons with which actions are done. Here's the problem. You can choose those actions, but you can't choose your reasons. It's going to be the same problem. It's impossible to use your will to pick out the reason for which you act. So if your spouse or your friend says, I really, really, really want to go to the following movie, and you both want to honor a loved one or somebody you care for by acquiescing to their request, just because you want to give them something. You want to give them your acquiescence. But you also want to go to the movie. You have an interest in the movie. Can you make it the case that you go to the movie because your friend asked you to? Can you will the reason for your action? I think the answer to that question is no, and there's, of course, a big literature on this. If you can't will the reasons that are the causal triggers for action, even as much as you can will your actions. You can certainly will your actions. But if you can't will the reasons for your actions, then we're in exactly the same boat of criminalizing what can't be autonomously affected.
Can't I will choosing to treat something as a reason? I can't will my reason, but I can choose treating it as a reason. If I realize that this is my reason, then I can realize, or should realize, that it's a bad reason.
You can recognize it is a reason.
Yeah.
You can recognize it is a reason. You can recognize that something is an objective indicator of right-making action or an objective indicator of wrong-making action. But that's not for something to function as a reason in the sense in which you need it to be, namely in a way that is in some sense action driving or motivational, right? That you can see that something is a reason doesn't make the reason operational. And you can't will its operational qualities. It just does operate or not. We're at the whims of our reasons.
Okay, well, I'll just first pick up on that last point. That seems like that line lead to very general skepticism about our autonomy or our rational powers. I mean, after all, we can't choose our desires or inclinations either any more than our emotions. But the common sense thought is, well, we can still choose whether to act on them or not. So. It seems that David's point still stands, or you're led into general skepticism. And the point I was going to make is actually somewhat related to that, since you draw a distinction between goals and emotions in a way that I find quite odd. So again, I think that desires or intentions they embody goals in just the same way as emotions or attitudes do. So fear might involve. First of all, it might itself be in part constituted by a desire to flee or desire to get away from the object of fear. Just using fear as a kind of paradigmatic emotion. But it can also be reasonably said to embody the goal to get away, to rescue yourself or whatever. And same way you could say that love embodies the goal that the person you love does well, or however you want to specify it, or the person that you care about. So. That sort of dichotomy between kind of goal states and emotion doesn't seem sustainable to me. Now, and I think I don't think that's necessarily damaging to your argument, since even if different kinds of states are equally goal-directed, it doesn't follow that they're all equally under our voluntary control, and that seems to be your main point. But it just seems kind of odd in terms of philosophical psychology to make the kind of distinction that you do.
Okay, good. So two things, two points there. The first is your worry that if you go down my path, you're headed on a slippery slope to skepticism altogether about agency and responsibility, right? And you say we can choose whether to act on our reasons. We can choose whether to act on our desires. We can choose whether to act on our emotions. Absolutely right. We can choose whether to act on our background emotional states. That's the point that the person who's about to throw the rock through the window of his neighbor, who he hates because he's a Jew, can choose not to act on that emotional response to the Jewishness of his neighbor. So sure enough, you can choose not to act on desires that you perceive, emotions that you understand that you have, and so forth. But you're not being punished for the enhanced penalty isn't for acting on that emotion. That's what the background already punishable offense will punish you for. The enhanced punishment is for doing that deed with that accompanying emotion or disposition, right? So I think it's entirely legitimate of the law to criminalize the throwing of a rock intentionally through someone's window, precisely because you can choose not to act on whatever emotions would motivate that deed. What you can't choose is not to have that thing that under contemporary hate crime statutes gets you the enhanced penalty, which is the having of that particular hatred as you act. Your second point, the notion that certain desires and emotions have goals built into them in the same way that fixed intentions do. Well, I take goals just to be fixed intentions. That's all I mean when I speak of a goal. It's a willed end state. It's a fixed intention. So that's the difference between a goal or an intention and a desire. I take there to be a significant difference between having a desire and having a fixed intention or a goal that you've settled on pursuing, right? Namely, you choose to pursue a goal, but you can't, of course, choose your desires. That's been the argument. But yours is an interesting observation that, for example, as you say, fear can be said to embody the goal to flee from the source of danger. Love, you said, embodies the goal that the person you have love for does well. Notice that's not analogous. So what you need is something that's like a goal. Love embodies the goal of furthering their welfare, right? So you need an action that follows. So now that's interesting, right? I'm ultimately going to resist that, but notice how tempting that argument is that Andy's proposed. Because ultimately, I'm going to suggest that while one, of course, correlates with and often causes the other, it isn't necessarily built in to the emotion itself, precisely because what a goal is a chosen end state. So I feel fear, that's why I choose to run from danger. I feel love, that's why I choose to do what I do that constitutes advancing behavior for others' interests. But it doesn't predestine or conceptually entail such further choices. I can love somebody without choosing to advance their interests at all. That would be perverse. You might ultimately doubt that I love the person because you don't have any epistemic basis for my claim that I do. But of course, it's perfectly possible somebody can be utterly and completely without the ability to act and love somebody. So, right, it's conceptually quite possible.
Heidi, I had a really clever point and a clever question that's gone out of my head, but I've got a backup.
Okay. We'll make that one as clever as we can.
Yeah, I'm pretty proud of this one.
Okay.
Listen, I agreed with lots and lots of what you say. I think if you're starting from scratch, law isn't an ideal route to go down. I think my worry is sometimes we can label people as haters or as having entrenched prejudice, and not so happy with that. And I also don't like interventions which mean that we have more people in prison for longer. It's not really a route I'd like to go down. So I understand and a lot of where you're coming from. My concern is this: when you get a situation like the UK, and we've gone down that route, we have our various strands of aggravated legislation, and there are problems there, and we've highlighted some of those today and yesterday. But there's something kind of reassuring as well in terms of having laws that act as a social barometer of where we're at. You know, that it's not okay to single out people because of their identity, and that's certainly the response I get from speaking to a lot of people, whether they've been victims or whether they're just friends, colleagues, whatever. They kind of like being in a society where we recognise that issue is significant. So that's something I was wondering what your thoughts are there. And the other thing, it's not really that clever a point. I'll come back to that, but if we can't have enhanced penalties, and I don't necessarily like that idea, but what about cleverer penalties? Penalties that include more of a restorative, tailored approach with the perpetrator. Why does that punishment need to equal a prison sentence or a longer prison sentence? Why can't that punishment actually mean less prison time, but a more tailored, restorative approach that deals with the issues at hand, whether it's hate, whether it's prejudice, whether it's harm, whatever it might be?
Good, wonderful. Okay. It is certainly true that, in some ways, of course, the notion, my argument is not that I'm worried about labeling people as haters if we put them away for hate crimes or if we enhance penalties. And I'm not, unlike you, as worried about prisons being full of people who are being ineffectively served on rehabilitationist grounds, because I'm not a rehabilitationist. It's not that I take it to be unfair to be labeling folks or that I'm as a general matter, distrustful of the institution of prison, to fulfill the mission I take the criminal law to serve. It's that ultimately I take punishment to be a mismatch when it fails to map on either, well, to culpability and wrongdoing separately or combined. The notion that law and legislation generally should function as a social barometer is tempting to many. It's what gives you an expressivist account of hate crime legislation. Not one I addressed in my talk today, but one that I address actually at a considerable length in that particular article and in other articles. Precisely because the notion that the law should be thought to send contradictory messages to criminals whose crimes should be thought of as messages themselves strike me as metaphorical in ways that are unhelpful, quite frankly. I don't know how to make sense of why mail fraud gets you, 7 years, and tax evasion gets you 12 years, and rape gets you 19 years. That is, I don't know how to make sense of the incredibly finely calibrated punishments that we dish out in response to a remarkable continuum of crimes on the basis of claims that they send messages of a certain sort and that we need to match those with in-kind contradictions. I just find the metaphor to run out really, really quickly. And I also take there to be embedded in expressivism an unfortunate willingness to use a defendant to send a message to the rest of the public in ways that might cause you to mismatch punishment to that individual's just deserts, right? That would be the worry. You'd overpunish or you'd underpunish relative to your ultimate goal, which is not to match punishment to their just deserts, but to do the message delivery that you've just straddled the system with. The second point, couldn't penalties be, rather than enhanced, couldn't they be smarter? Sure, absolutely. If you're going to put people away in prison in a manner that matches the penalty, the loss of liberty, to their relative responsibility for wrongdoing, you might as well, while you're at it, be engaged in, for example, efforts at rehabilitation, right? Efforts at restoration. While they're in there, it would be nice if we did some good. It's not my goal for why I would punish them, but it certainly can be justified as a kind of side effect that while we're punishing them, so we're attempting something better than mere loss of liberty, right? And that's just to say there's lots we could be doing while they're behind bars that could be advantageous to them as moral agents and advantageous to us as a society.
Unfortunately, I have to stop the discussion now, but thank you very much.
You're welcome.